And hello again. Employment Law Show. John Scholes, Lior Samfiru, here to fill your head with wonderful knowledge for the thing that you do most of your life. That is probably 8 hours a day. Your working life, you're in the office, you're working, you need to know your rights. If you've watched this show before, you're ready to hunker down and learn something new today. If not, you can email anytime, help@employmentlawyer.ca. Call that number, 1-855-821-5900, and an absolutely free resource for you. It's like having an employment lawyer with you at all times. pocketemploymentlawyer.ca. We'll dig down into that a little later on in the show. Plus, coming up today, dismissal for cause in Canada, what you need to know. But first, we always start with the week that was, something that's been happening on your side of the desk. Lior, what's going on with you?
Another busy week for me, and a lot of questions answered, emails answered, phone calls had, spoken with a lot of people. I try to speak to as many people every week as possible to answer questions about workplace rights, to solve problems when it comes to your job. So please, don't be bashful. If you've watched the show and you say, I wish I could reach out to Lior and ask him a question, well, you can. We give out my contact information throughout the show. You can call, you can email, we can connect and discuss your workplace issue. And the reason you want to do that is I can assure you there are answers, there are solutions, and there are options. So if you think you're in a dark cave and there's no options, wrong. I can light the way. I can tell you what you need to know. So if you're in that situation, please reach out to me. I'll gladly talk to you. And every week, I like to start off with the week that was, as John said, talk about some situations that came across my desk. Well, for some reason, over the past week, I've had a number of people contact me with the same issue. Namely, my employer is ignoring my doctor's note. My employer is not believing what the doctor is saying. And usually, especially now during the COVID times, it comes down to, I can't go back to the office because of a medical reason, and here's my doctor's note. And the employer says, no, too bad, you're still coming back. Well, wait a second. It doesn't work that way, okay? Your employer does not get to decide if they believe your doctor's note. They don't get to decide whether, in fact, you are sick. The only one that can decide if you can work or not, if you can work in the office or not, is your doctor. And once you have that doctor's note, the employer cannot do anything. So now, during COVID, if there's a medical reason that your doctor corroborates that makes you unable to go back to work, again, that's up to your doctor. But if that's what your doctor feels, you can be off work. Provide that doctor's note, and your employer would also have to accommodate you. If you are able to do your job from home, but you can't come into the office, and there's a doctor's note, yeah, your employer may have to accommodate you by allowing you to work from home. Now, it's not enough for you to say to your employer, I'm not feeling comfortable. I don't want to go back to the office. I have an immunity compromised situation. No, you saying that, unfortunately, not enough. Your doctor saying that, absolutely enough. And at that point, your employer has to accommodate. And if they challenge you on it, if they refuse to accept it, if they say, no, we don't believe it, you reach out to me. I'll remind your employer what their obligations are, because whatever your doctor says is all that matters, and your employer cannot argue with that in any way.
Anytime. By the way, you can slide over to employmentlawyer.ca. There you will find a resource for our radio shows, which have been going on for years and years. We got a lot of phone calls. People have questions every week on the show, and we play some of them back here. We cherry pick them when we talk about them. So this, Lior, will be the first call from the radio show right now.
I'm 65, been with the company 35 years. It's a multinational company, financially strong. When I started with this company, we had virtually no sales. We'll do $100 million this year. So with COVID, we're looking to restructure it. I believe there's a package coming my way. I don't know what it's going to look like, and I guess what I'd like to get is an understanding of what it should look like based on what I've given you.
Can I guess how much?
Yeah, well, I hope that most of our regular viewers are jumping up and down saying, I know what this person is owed, because clearly, after all this time, he's had 35 years, he has significant entitlements. Now, before we tell you exactly how much he's owed, these are the main factors that go in: your age, your position, and the length of your employment. Now, this person is 65 years old. He's been there for 35 years, so he scores very highly on that scale. Now, for most people, you should know that the maximum that anyone is owed is 24 months pay. 24 months pay. Now, in some situations, you could get more. You could get as high as 26 or even 28 in some situations. But for most people, it maxes out at 24. So let's get rid of the suspense finally. Let's take this person's information and let's plug it into pocketemploymentlawyer.ca. So we'll go to pocketemploymentlawyer.ca. We'll plug in the information. 35 years of service, 65 years old. Not surprisingly, no shock to anyone that he gets 24 months. It's as simple as that. Clearly, he would get the maximum. By the way, you could do the same thing. If you think there's a severance package in your future, maybe your employer is making some changes, cutbacks, you want to know what would I be owed? I need to plan, I need to know. You can know right now, literally right now. Just go to pocketemploymentlawyer.ca. You can calculate your severance there in seconds, free and anonymous. Maybe you're actually looking at a severance package and you want to know if it's right. No point of wonder anymore. Or maybe you're just curious. Hey, I don't think they're letting me go, but wouldn't it be nice to know what would happen if? Very easy, very simple. pocketemploymentlawyer.ca.
Yeah, you tried to sell it once as a home game. Didn't really take off. I don't know why, but it's a good tool, regardless.
Yeah.
The makers of Monopoly are not worried, pal. Sorry about that. But.
No, they're fine. So check it out. Well, the home game may be coming in a revised edition later on. For now, pocketemploymentlawyer.ca.
TerminationQuestions.com. That's another, seriously, an amazing resource. You can ask questions there. Lior or a member of his team will get to them and answer them and give you a reply. We'll get to one of those for today. This one comes from Aaliyah. Says, hi, guys. Our team was shifted to remote work from home months ago due to COVID-19. Our employer just informed us that they will permanently trim our pay by 15% because our personal expenses, commute, work attire, lunches have all dropped. Is that fair?
And actually, I've been getting this quite often. In fact, I've even seen some articles written about this, that employers are saying, well, wait a second, we're going to let people work from home. They have less expenses, maybe, so why don't we just reduce their pay? That sounds right. Well, no, it's not right at all. Absolutely not. Regardless of what your expenses are, your employer cannot decide to reduce your pay. Certainly not when it comes to more than 10%. If they do, you have the right to treat that as a constructive dismissal. Now, it is true that maybe if you're working from home, you have some less expenses. You're making your own lunches at home. You don't have to pay for public transportation or parking. Fine. Regardless, your employer cannot touch your pay. If they do, if it's more than 10%, you have a choice to make. You can accept that reduction if you want and continue working, or you can treat that as a termination. We call that constructive dismissal. Our regular viewers know about that, and require the company to pay you severance. So for employers, if your employees are potentially spending less or have less expenses, that does not give you the right to change their compensation. You can talk to them, see if they'll be agreeable, but for those employees that do not agree, if you do reduce their pay, certainly if it's more than 10%, you're going to be running the risk of facing constructive dismissal claims. So very important to keep that in mind now during COVID-19, and applies, by the way, to other changes to bonuses, changes to your vacation or your hours of work. If those changes happen, regardless of the reason, that may well be a constructive dismissal.
I would imagine that this type of change with some employers, if not already soon, if it does happen, that might not be a verbal thing that they're just telling people. This might come down the pike as a new employment agreement for people to sign mid-employment. They should be watching out for that, right?
Do not sign it. I'll make it very simple. If you're mid-employment, as John said, and you're getting a document to sign, do not sign it. Do not sign it, because I can almost guarantee you there are going to be terms in there that are going to be unfavorable to you, the employee. Terms that reduce your severance later on, terms that reduce your job security, that give the company rights that it didn't otherwise have. So anytime you're introduced out of the blue a new employment agreement, be concerned. Send me a copy of it. Let me read it. Let's have a discussion about what it does and what it means. If you don't care about it now and you sign it, you'll certainly care about it later when your employer wants to actually use it to its advantage.
Dismissal for cause in Canada. What is that all about? We'll find out, but first we'll take a short break. In the meantime, reaching out again, help@employmentlawyer.ca is the email address, and 1-855-821-5900. Stick around, there's lots more Employment Law Show on the way.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. John Scholes and Lior Samfiru answering your questions. And you can go to terminationquestions.com anytime you want to ask a question. And the handy tool is pocketemploymentlawyer.ca. That is created by Lior a couple years ago now. Inside that as well as the severance pay calculator, but it does so much more. It's absolutely free and anonymous. So check that out anytime, pocketemploymentlawyer.ca. But we're talking about this dismissal for cause in Canada, what you need to know. Obvious question right off the top, pal, is what is dismissal for cause?
So dismissal for cause is one of two ways an employer can let an employee go. Oftentimes, non-lawyers may refer to it as being fired. The legal term is a dismissal for cause. And a dismissal for cause is a situation where an employee is being let go because of something awful that they did, okay? It's a situation where the employee did something so bad that the company lets them go because of that. And it's a very difficult thing to establish, and frankly, it's a rare thing. Now, I say it's rare because legally speaking, it can happen in very limited situations. It's not so rare in that employers often try to terminate someone for cause when it's not really legal. So really, in essence, a termination for cause is where the employee did something that makes it impossible to continue employing them. And if that's what they did, they can be let go at that point for cause, without compensation and without severance.
Is it generally hard for an employer to let someone go for cause?
It is very difficult to establish cause. I like to refer to it as the capital punishment of the employment relationship because, just like capital punishment, it's only for those that are the worst offenders. Other offenders, someone that may have done something wrong, may require some form of discipline, but not a termination for cause. So the fact that you did something wrong, or maybe you've done a few things wrong, does not mean that you can be let go for cause, does not mean you can be let go without severance. There's other forms of discipline that are available to an employer. An employer may be able to provide you a warning, a final warning. An employer may even be able to suspend you. In some more extreme situations, there could even be a demotion that an employer can do if your conduct is really bad. But a termination for cause, really, it's for the worst offenders. Either the employee did something terrible. We're talking about they stole, they committed fraud, they hit someone. Yeah, if you did that, that's going to be cause any day of the week. Or situations where the employee had really bad behavioral issues or bad performance, and the employer documented, they gave warning after warning, the employee certainly did not improve. Well, at that point, what can the employer do but terminate for cause? But John, in my experience, most employers, the vast majority, in fact, of employers, pull the trigger on a termination for cause well before they should, and that, John, would be a wrongful dismissal.
I know a lot of employers, and I know you've had this conversation with both employees and employers that have given you a call saying, I'm under this 3-strike rule that, I did 3 things wrong and that's enough, out the door. Does that work?
It's not that straightforward, not at all. So there's no such law that says 3 strikes and you're out. In some situations, 3 strikes is too much. In other situations, it's not even close to being enough. In other words, the punishment has to fit the crime. So if you've been late 5 minutes 3 times, guess what? You cannot be let go for cause. If you've been late 2 hours 3 times, and they've documented properly, we may be talking about a cause at that point. What more can the employer do? But if you've been warned 3 times, and again, depending on how much gap there is between warnings, if you've been warned 3 times, but the last time was 2 years ago, it doesn't really matter. The clock pretty much starts running fresh now. So no, there's no rule like that. And as I said, even if an employer has a policy that says there's 3 strikes, the law makes that determination. The law decides whether the punishment is appropriate, not your employer. So you've done something wrong, you've been warned before. In and of itself, that does not mean you can be let go for cause. That may well be a wrongful dismissal, meaning you would be owed your severance.
We are talking about dismissal for cause here. If you have any more questions that come up while we do this, you can reach out anytime. 1-855-821-5900 would be the phone number, help@employmentlawyer.ca. If I am let go for dismissal for cause, do I lose my right to severance?
So you would only lose your severance if, in fact, the employer actually has cause. Not enough for the employer to say, hey, we have cause. Not enough for the employer to think that it has cause. If in fact there is cause, if you've done something terrible, or if your employer has documented and warned you about your issues and misconduct, yeah, maybe then they can let you go for cause and avoid paying you severance, but only in those limited circumstances. Remember, an employer can let you go with severance pretty much for any reason. So as long as severance is paid, you can be let go. We're talking about a situation where severance is not paid. And the reason we care about severance, because severance for many people could be as much as 2 years' pay. So the difference between being let go with nothing and being let go with 2 years' pay is huge. It's very, very significant. But if there is truly cause, if your behavior was bad, if you were warned and you continue in that behavior, yeah, at that point, maybe the employer can let you go for cause and you would lose your severance. But it is always important to check yourself and check what happened to determine whether it's legal. And by the way, we mentioned earlier on the show the pocketemploymentlawyer.ca tool. Well, one of the other things that the tool does is allows you to determine whether, in fact, the company had cause. So you don't even have to call me if you don't want to. You just go to pocketemploymentlawyer.ca, you answer a few questions, and you find out, is there cause or is there no cause, and how much severance you're owed. So check out pocketemploymentlawyer.ca.
So I'm an employer watching this show today, and I thought, okay, the 3-strike rule, I get that. That's vapor. That doesn't actually exist. So how do I actually build a case if I have an employee that I eventually want to let go for cause now?
So an employer should build up its case if it thinks it may have to terminate an employee for cause. That's not necessarily an easy thing to do. So number one, you want to document any forms of misconduct. So you saying, well, I remember 6 months ago you did something, that's not enough. There has to be some sort of a record of it. So write things down, maybe have the employee provide an acknowledgement that they did something. There has to be a way for the employer to document it. Second is discipline the employee. If the employee does something wrong, tell them about it. Give them a warning. Tell them what's expected. Give them time to improve. If they do something wrong again, do the same thing. Tell them, again, we talked to you about this. You're still doing this. We're giving you another warning. Maybe if they do it again, give them a final warning. And if it still continues, yes, maybe then you can terminate for cause, okay? You have to give the employee enough time to show improvement. You know, if you tell them do this differently and tomorrow it happens again, that may not be good enough. But you cannot skip steps in the process. You have to put in the work if you're the employer. If you want to terminate for cause, you have to document, provide warnings. You have to be able to show that you, the employer, did your part, that there really was nothing else that you could have done. If there was more that you could have done, it's probably not going to be cause, and the employer will find itself on the wrong end of a wrongful dismissal.
Employmentlawyer.ca. Again, that's the website you want to check out and reach out if you have any more misconceptions about what we just talked about, dismissal for cause. And if you want to catch our radio show as well, there's links to stations where you can do that each week. Phone call number 2, Lior from the radio show is coming up now.
So I've been temporarily laid off of my job, and they're slowly calling people back. They started, I think, like 2 weeks ago to call people back, and they haven't called me back. So I'm just wondering, how long is a temporary layoff supposed to last before I could get a severance?
Get that question all the time.
I've been getting that question daily, multiple times a day, 7 days a week. So there's an incorrect assumption built into that question. And the assumption is that they have a right to lay me off as long as it's for a certain period of time. So let's be very clear. Your employer does not have a right to lay you off temporarily. Doesn't matter where you are, the type of job, doesn't matter if it's COVID related. In other words, on day one of that layoff, you have a right to treat that as a termination. You have a right to say, I'm not accepting it and I'm leaving with severance. That's a constructive dismissal. And John, the example that you and I often use is this. Well, if your employer reduced your pay by 50%, clearly we would know that that's illegal. Clearly we would know that there's something we can do about it. Well, what is a temporary layoff? It's not a 50% reduction. It's a 100% reduction in your pay. That's why it is illegal. Your employer cannot do that. The deadlines that you hear about in terms of can you be laid off for this long or that long, it's only if you choose to accept the layoff. So if you choose to accept it, then it can only last for a certain period of time. And depending the province that you're in, if you're in Ontario or BC or Alberta, etc., then there's different timelines. But that's only if you choose to accept it, which you don't have to. Now, in terms of being called or other people being called before you, once you've accepted the layoff, the employer doesn't have to follow seniority in terms of calling people back. Certainly that's true in a non-union environment. So in and of itself, the fact that other employees that are more junior than you were called back and you weren't called back, that in itself is not really illegal. What is illegal to begin with is the layoff. So if you've been laid off temporarily, if you don't know when you're coming back, you have a choice to make. You can choose to accept that and stay on a layoff and hope for the best. And depending on where you are, you could be waiting a very, very long time. So let's call that option number one. Option number two that you have is you can treat that as a termination. Now, you don't have to wait. You don't have to worry about, are they going to call me back? You don't have to worry about, how am I going to pay my bills? You can get your severance, which, as I said before, could be, for some people, as much as 2 years' pay, and then move on. If that's what you want to do, if you don't want to sit at home and wait, if you want to take your severance right now, give me a call. Let's talk about that, and let's make that happen.
So you've been given a pay cut even though the company is getting some government assistance. We'll tackle that after a short break. The number, as mentioned, 1-855-821-5900 and help at employmentlawyer.ca. Still more to go. Employment Law Show. Stick around. We're coming right back.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Welcome back. Employment Law Show. Employmentlawyer.ca is the website. There's a list of places you can find our radio show and catch a show and contribute if you want to make a phone call, ask some questions. We get a ton of them every week. And phone call number 3, Lior, which we're going to play right here and answer it.
I've been working from home since the COVID-19 has started, and they laid all the employees off, so I've taken on everybody's roles. But they also gave me a 25% cut on top of that, and we ended up getting $18 million from the government for assistance, which no one has seen yet. I've been there for 5 years.
Great. More work, less money. We love that.
Perfect combination.
Totally.
So I want to start answering this by talking about government assistance.
Right.
So I've got a lot of calls from people that are saying, well, we know that the company's gotten government assistance, they've gotten wage subsidies, but I, the employer, am not seeing any of it. Is this wrong? And the answer is, yeah, absolutely it's wrong, but it's not necessarily something that you, the employee, can do something about. That's between the employee and the government. Yeah, they may be held to pay potentially to the government if they're abusing or misusing the money, but that doesn't necessarily give you rights if the company is doing something illegal with the money they're getting from the government. What gives you rights is the fact that you're taking a pay cut. So this person in the call that we got on our radio show said, I took a 25% pay cut. Regardless of how we got there, regardless of whether or not it's COVID or not COVID, the employer did not have a right to make such a pay reduction. Remember, really anything over 10%, certainly if we're talking 15%, here it's 25%, that's a constructive dismissal any day of the week. So that is the issue. The issue is she's taking a pay cut. So her option is this. She can obviously accept the pay cut and continue working. The problem with that now becomes the terms of her employment. And if her employer never brings her back to 100%, she's stuck in the 75% pay forever. Not a good thing to do. So that's option number one still. Option number two is she can treat that as a termination. Regardless of the wage subsidy or not, the pay reduction itself is illegal. She can treat that as a constructive dismissal and say to her employer, I'm not accepting that. I'm going to leave because of this pay reduction. Now you have to pay me my severance. Then the next logical question would be, okay, for this person, how much severance does she get? So we know where to go. We've done this before. Let's do it again. Let's go to pocketemploymentlawyer.ca and let's plug her information in to that calculator portion. So we know she's been there for 5 years. I picked an age, let's say she's 53 in a clerical role. We see at the bottom of the screen there, she's owed right around 6 months' pay. 6 months' pay is what she'd be owed. So that's what's at stake for her. She can reduce her pay, accept that now she's making less money, potentially forever, or she can say, no, I'm going to leave. I'm going to make you pay me 6 months' pay at full compensation, and I'm going to go ahead and find another job.
Is it not only the fact that she could be making less money forever, but now she's giving the employer the right to do it again, another 25%, another 25%. Pretty soon she's paying them.
It gets worse, exactly.
Yeah.
By allowing the company to do something that the company is actually not allowed to do. They're not allowed to reduce her pay, but by allowing them to do that, by accepting it, she's given them the right to do it again. So the next time they reduce it by 25%, and the time after that by another 25%, she won't be able to do anything about it. You only have that ability to stand up for your rights really one time. And if you give up those rights, then you may not be able to get them back. So not a good idea to allow the company to reduce your pay, because it's not necessarily going to end there. The next time they do it, you may be stuck, and that's not a good situation to be in.
We got time to slide back over to terminationquestions.com and get another question answered, Lior. This one from Eva says, I was unexpectedly fired nearly a year ago. I had worked there for about a decade and am still looking for work. The business told me that because I qualified for EI, they weren't required to pay me severance. Is that true?
My God, I keep hearing new reasons or excuses for employers saying, well, we don't have to pay severance because. We don't have to pay you severance because you're 6 feet tall. We don't have to pay you severance because you have a car that's an automatic. Whatever. There's always reasons and excuses, and they're all false. They all make no sense. So this employee's ability to qualify for EI does not mean her employer doesn't have to pay her severance. Now, you cannot get severance and EI for the same period of time. So if you get severance, that means your EI may not start until later, until the severance runs out. But you're better off getting severance, because severance is your full compensation, where EI is capped at a portion of your compensation. So if you have an option to get 10 months of severance or 10 months of EI, it's a no-brainer. Yep. 10 months of severance. And again, you don't lose your EI, it just gets postponed. So no, that is wrong, that is false. You still get severance if you qualify for EI. Don't let an employer try to find creative reasons to avoid paying you. If you're not sure if you're owed, if you're not sure if what the company is saying is right, rather than taking their word for it, give me a call. Let's talk about that, and let's get the truth on the table.
Last minute so here, Lior, just tell me a little bit about the fact that temporary layoff, COVID hasn't changed that. That has not changed that rule, has it?
You know, there's almost an assumption right now that a temporary layoff is right, because so many people, millions across the country, over the period of 6, 8 months now, have been put on a layoff temporarily. So there's the assumption, well, if it's been happening across the board, it must be allowed, it must be legal. No, please don't assume that, because the opposite is true. Even if it's COVID related, a temporary layoff for most people is not something the employer is allowed to do. It is a termination if you choose to treat it as a termination. So whenever you've been laid off temporarily, COVID or not, you have that choice, that option I was talking about earlier. You can accept it and then wait at home, and depending where you are, you could be waiting months and months and months, but that's your right, no question asked. Or you can treat that as a termination. It's not allowed. You have the ability to choose. You don't have to wait for the company to give you an answer. You can come up with the solution. You can come up with the answer, which is to treat that as a termination, get severance. If you want to do that, give me a call.
A lot to digest on every show, so if you're a little bit befuddled, that's okay. Make the phone call, make the email, get some more information. 1-855-821-5900 is that number. Terminationquestions.com to ask a question there, or you can send an email. That is help@employmentlawyer.ca, and always consult pocketemploymentlawyer.ca as well. Appreciate you sticking around. We'll catch you next time. Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.